Hey there, everybody. This is Jonathan. I hope you are all doing well and staying warm. Here in Atlanta, where I'm at, it's about 30 degrees outside, and they're predicting 2 to 4 inches of snow on Friday. We don't get snow very often, so it's going to be kind of interesting. All the stores, I was the Publix earlier, and people are all the dairy is bought out, the bread is bought out. It's like, the apocalypse coming. So I hope where you are, it is not ridiculous weather. If those of you in California, I have a cousin in California, and I know there are wildfires out there. So if you're in California, please be safe. Just crazy weather. So again, I hope wherever you are staying warm and you are safe. So, been out for a couple of weeks, was on kind of a little family vacation, went to Hilton Head, which was very nice. Mostly pretty warm. Wasn't as warm as it was earlier in the year, but it was probably in the 50s and 60s. So it was nice to walk on the beach and play a little tennis and just kind of relax. But I'm back. I had two hearings today, one by video, one by telephone. I think they both went pretty well. I've got another one on Friday that looks pretty good. So we're kind of starting the new year with a bit of a bang, which is good. So anyway, we'll kind of jump into some questions. Actually, there are a couple of things I did want to talk to you about before jumping into questions, and that is Social Security has come out with some new forms regarding the form of hearing. And I mentioned this before, but now audio hearings, telephone hearings are the default, meaning that if you don't say otherwise, they will schedule a telephone hearing. And that's great. Telephone hearings work really well. There's usually not a lot of technical issues, which there can be with video hearings. In-person hearings you can still request, but you've got to do it specifically. Up before COVID, in-person hearings were the de facto standard. Now audio hearings are. But Social Security in its own ways managed to make this somewhat simple process complicated. They will send you a bunch of forms. One of the forms says, it's an object form HA 55, and it basically says, I object to appearing by audio or video. And if you send that back, they will schedule an in-person hearing. But if you don't send it back, they'll schedule an audio hearing. It just doesn't make any sense. Why don't they just have one form that says, this is what I want? In fact, we've been using a form put together by NOSCR, the National Organization of Social Security Claimants Representatives, where we choose audio, video, or in person, or audio or video or in person. But instead of having one form, they've got like 3 forms. And they've got another one where you get it and says you can choose for a video, but if you don't send it back, it won't be scheduled by video. It's just very, very confusing. I've had clients call, like, what do I do with all these forms? They get a form from Social Security and an envelope, but then they're not supposed to send it back. So very, very confusing. So what I'm telling my clients is when you get these forms, just call us. We will make sure that the audio, or if they want video, that is appropriately requested, but just be aware that if you're doing this on your own, or even if you have an attorney, you're going to get these forms. They're going to be very, very confusing. Don't be confused about them. I'll try to get a screen capture video out. I'll have to get some of the forms, and I'll redact the personal information. But the bottom line is that audio is the default. Video you have to choose. In person you have to choose. But it's really confusing when you get forms that they tell you, don't send these in if you don't want this, and it's just this double negatives, which is just a bit ridiculous. But again, this is what we get from Social Security. So anyway, let's go ahead and jump in. We've got some, Fong Trong, good evening and thank you. Good evening, Fong. I hope you're doing well. St. Louis Grand, who's one of my regulars. I hope you had enjoyed the holidays. We did. I took the grandbaby, my wife, my son and my daughter, son-in-law, and we had a nice time walking on the beach and doing all kind of eating too much pizza and ice cream and things like that, which is what one does on vacation, which was nice. It's nice to get away. Okay. So St. Louis Grand says, a person got a letter from OHO, the Office of Hearing Operations, in October about the need to schedule a hearing for a district court remand. It was not scheduled in January. Person called OHO. Rules call for the VA 100% permanent and total on remanded claims. So basically, you should get a faster hearing if you're 100% VA disabled. Supposed to be expedited. They're scheduled for 3 months from now. They're talking about emailing the senators. It's a good idea. I think that realize when they schedule a hearing, the earliest you're going to get it is going to be about 3 months out. What you can do is contact, or your attorney could do, is contact the hearing office and send a waiver of advance notice. And what I've done in the past is, if I have a case and I want to expedite it, I will say, I am ready whenever the judge is ready. I make sure I'm prepared for it. And if you have a cancellation, and you want to give me, 1 or 2 days notice, I am ready. I don't know that contacting your senator is going to do very much, because a 3-month advance notice is not is considered to be expedited. So you are actually getting an expedited hearing. But again, the only thing you could theoretically do other than that would be, what I would do is I would prepare a brief where I set out the theory of my case. I would then let the judge know in writing that I'm available at any point with 24 or 48 hours notice if there's a cancellation. I've had that work a couple of times, but again, depending on the judge, what the judge wants to do. So I hope that answers that question. But contacting the senator, you can. I just don't think it's going to do any good. All right, Laura Dunnigan, thanks for doing this talk. You're welcome, Laura. To meet a musculoskeletal listing, do I need to use 2 canes all the time, or it will be okay for PT, so even for longer walks to the store? I think that, again, the listing requires, for musculoskeletal, which is listing 1, and they make that really hard to meet, you have to have objective testing showing that there is some sort of documented problem with your spine. So it's not just the walking, but again, the result of it needs to be that you have problems walking. I don't think 2 canes is necessary, but if you need, walking outside of your home, if you need what they call an assistive device for walking outside your home, that would contribute to possibly meeting the listing. But it's going to take more than that. Certainly in a grid argument or a functional capacity argument, needing a cane can be very significant. One of my hearings today, I have a client who is over 55, and because of a bad accident and knee surgery and some obesity, she has to have a cane in the house and a walker out of the house. And by definition, if you need an assistive device, you cannot do light work. Light work being defined as standing and walking 6 out of 8 hours in a day. But if you have and lifting 10 pounds frequently, 20 pounds on occasion. And if you need a walker or a cane, then your hands are tied up. You won't be able to lift. And by definition, you won't be able to do light work. So that would mean that if you're over 55, assuming there are reasons you wouldn't be able to transfer your skills, like pain medication or pain, then you meet the grid. That's exactly what happened. The judge announced on the record that my client met the grid and is going to approve the case. And I made sure I asked him, we prepped it ahead of time. I said, how long can you walk and stand, even with the cane or with the walker? And she said, 10 or 15 minutes, that it was very uncomfortable. And I said, when you were working, because we had to get rid of past work, how much standing and walking were you doing? And she said 3 or 4 hours. Perfect. We got rid of past work, and we showed that because of the walker, the assistive device, she was not able to do light work. Therefore, she met the grid. I argue that she met the grid at sedentary, and because she was 56, there's the minimal vocational adjustment standard that applies under what they call the POMS, and basically that means that Social Security would have to prove that there was really essentially the same job she had done that she could do at a sedentary level. Her case, there was no such thing, so we won on that basis. So the combination of prepping this properly and making sure she testified about her past work, and the fact that the medical record showed she needed an assistive device goes a long way. So I would tell you that big picture, Laura, if you need a cane for walking outside of the home, that will generally eliminate light work and will reduce you to sedentary work. And if you're over age 50, that's a good chance that you'll meet the grids. And even if you're under age 50, needing to use an assistive device will eliminate categories of jobs. And presumably the reason you might need a cane would be because of significant back issues. Therefore, I think that would bode well for you as far as winning your case. So definitely, big picture, if you need an assistive device, that is a real positive sign, no matter how old you are, but especially if you're over the age of 50. Don says, he's 61, have metastatic problems. Very sorry, Don. Hear that. Filed SSDI on August 6th after a tumor found in your stomach. Obviously, it had spread. Claim a determination from November 20th. Gave him grid rule. I don't know that the grid might apply here, but I think you might look at the compassionate allowance or the listing for prostate cancer. I think that you might very well meet a listing or meet the compassionate allowance. I think you could also argue that under a functional capacity argument, that the combined effect of the symptoms you're having plus medication side effects plus weakness would preclude any kind of work. But the grid 202.06 basically says that you're disabled if you can't do light work, and that may be the case, but realize the grids they look at your physical limitations. And yes, there can be physical limitations arising from prostate cancer, but it seems to me that more of the limitations would be medication side effects, weakness, nausea, maybe bathroom issues, things like that. So that I'm not sure that the grids would be my first argument. I would certainly include it in there, but look at the compassionate allowance, look at the listing, and then also argue functional capacity. So as we've talked about here, there are three ways to win a disability case. One is to argue that you meet a listing. If you go to my website, meetalisting.com, you can look at the listings. It's linked there. The second way, and listings are basically where Social Security has identified medical conditions that on their face inherently are going to be disabling because of the nature of the symptoms or because of the nature of the treatment. In the case of many cancers, the treatment, the chemotherapy, the radiation can cause functional limitations in addition to the cancer itself causing pain or weakness or need to rest, things like that. So listings are one way to do it. And within listings, there's something called compassionate allowance, where if you have a condition that is life-limiting or significantly life-changing, compassionate allowance says Social Security should expedite those cases. So again, compassionate allowances are kind of a subset, of the listing. If you look at all the compassionate allowances, they all reference a listing. There's also something called TERI, T-E-R-I, which stands for terminal illness, where if you have a terminal illness, which I hope you don't have, Don, because I know the prostate cancer can be sometimes managed, but if one has a terminal illness, that is also a subset of the listing, that would be expedited as well. So I would look at compassionate allowance for prostate cancer as well as the listing and ask the adjudicator to expedite on that basis. I think the second way that one can win is the grid rule, which is basically over age 50, if you have physical limitations, the grids change the way Social Security defines disability. Under a grid rule argument, you can be found disabled even if you have some functional capacity for work. So it doesn't require that you to show that you can't do anything at all. You can be found disabled even if you can do sedentary work or light work, depending on your age. And at 55, it becomes even easier. And at 60, we also have some additional, kind of, again, I hate to call it subset, but a corollary to the grids at 55 and 60, that there is something called the POMS, P-O-M-S, which is kind of some regulations that say that over age 55 or over 60, depending on your, what your limitations are, that Social Security would have to prove that you could only make a minimal vocational adjustment. So again, it becomes even hard to another job. It becomes even harder for them to prove you could work. So again, the grids are really powerful if you have physical limitations and you're over 50 and even more so over 55. So the second way to win is based on the grids. The third way to win is based on what is called a functional capacity analysis, where you argue the combined effect of the symptoms, the treatment, the medication side effects, what they call comorbidities like depression, anxiety, other medical issues that may not on their own be disabling, but the combined effect of it That's my microphone there. Would be disabling. So that might be another way to go. And whenever I make an argument, I put that in. Let me put this back on here. I put that in that, please evaluate under the grid rules, or please evaluate under the listing in the alternative. Please evaluate under the grid rules in the alternative. Please consider a functional capacity argument. When I say in the alternative, in the legal world, when you make an argument, you can say there are three ways for me to win. Way one, but if doesn't work in the alternative, consider argument two. If that doesn't work, consider argument three. So it's not improper or inappropriate to argue all three, even if they seem to be internally inconsistent. Because again, if you're arguing functional capacity, you're almost sort of saying by definition, I don't meet a listing or I don't meet a grid rule. But in the legal world, you can make seemingly inconsistent arguments by using something called the alternative. And again, when I fill out an application or fill out an appeal form, I will make those arguments in the remarks section. So if you're doing this on your own, don't be afraid to tell the adjudicator, look at the listing, in the alternative, look at the grid rule, and as you identified the specific one. You might also look at 201.06, which is if you're limited to sedentary. So give them as many choices as possible. Same grid, but it's just with sedentary, not light. So again, it requires them to find you have less capacity, but it also would work. Or again, the functional capacity argument. So I would argue all three, but it seems to me that the grid rule in a metastatic prostate cancer case would probably be the one I would think is the least applicable. I think the listing with compassionate allowance would be number one. I think, you could certainly put the grids in there. I think functional capacity would probably be another one, and then you, of course, could argue the grids. At the end of the day, I don't care how a judge or an adjudicator approves my case, just approve it. And I have plenty of times where I'll make an argument that the grids apply, and I think they do, and the judge will approve it based on functional capacity. I don't care. As long as we win, that's what you want. So, Don, I wish you the best, and I hope that's the situation. Okay, you did flag compassionate allowance. All right, so and I apologize, I didn't see the rest of your comment there. So he's called the caseworker or the adjudicator twice, faxed records twice, flagged the compassionate allowance, which is what we were just talking about. I would reach out to your U.S. senator. I think what I would do is I'd contact your senator and say, look, I have a case that appears to be a compassionate allowance case. I've contacted the adjudicator. I've given them the compassionate allowance citation. I've given the listing citation. I'm not hearing anything back. I've sent them the records. Will you write a letter and put what they call a congressional inquiry into that? That would be the best way to speed it up, because these adjudicators get really busy, and sometimes even if it's a case that should clearly be approved, I've got one right now that I'm just like boggled my mind that they didn't approve it, but they didn't approve it. So we're going to have to appeal it. So again, just you got to be the squeaky wheel. But that's how I would do that. So I hope that answers the question, Don. And again, I do wish you the best. I know that there's for prostate cancer, there's medicines like Lupron. I'm sure that your doctor has talked to you about, which is a testosterone inhibitor, and that can sometimes slow things down. And there's other things they can do to hopefully get this under control, where you have an extended life expectancy. Sonia Fox, when should I consult you to see if you represent me? I believe it can be approved with the listing. 57, can I tell them what listing? Can I highlight the doctor notes for them? And let's see, the second part of this would be, thank you for your help. Yes, I think all those things, and look, some people reach out to me at the beginning. They say, just take care of it. I'd rather you do it. Other people say, let me go ahead and try it. I will file the application. I will reference the listing. I will send the medical records in. Let me see if I can win on my own. If they can, great. They get 100% of their past due benefits. They don't need me. That's perfectly fine. And as you probably have looked at some of my testimonials, I've had plenty of people say that the videos that I've got out there, or even this live stream, have given them enough information to win. So I would say, Sonia, if you want to do this on your own at the initial, go for it. If it looks like it's too much for a pain in the rear end, I get involved at any stage, and I'd say probably about 30% of my cases, maybe even higher, people just say, just you handle it, and again, I would reference the listing in the application. We also, the one big advantage I have when I get involved early is I will have access to your electronic folder with Social Security within a few weeks, and I can upload things directly. And kind of going back to something that Don had talked about, that he sent the records in twice. This is an ongoing problem. You send them in, they don't always get to where they're supposed to go because you're supposed to use a barcode or they get lost. And so again, one advantage I would say that an attorney does have, whether it's me or anybody else, is we would submit those records electronically. They would not get lost. They would be associated with your file. Doesn't mean the adjudicator is going to read them right away, but they're not going to be lost in Neverland. And this is something that happens more often than it should. I've got a case right now, for example, just to give you an idea, this happens, to me, in that when we represent somebody, and I will tell you how this is going to change, but right up until this point, we would have to get paperwork, an appointment of representative form and a fee agreement, and we would have to mail it in to Social Security. And they're supposed to put it in their computer system and reference me as the attorney. So I have a case out there where we mailed everything in. They got the part where I am representing the person, the appointment of representative form, but they didn't put the fee agreement in their system. Case gets approved early, great, but they don't pay me. Why? Well, you don't have a fee agreement in there. Of course I do. Everything's part of the same process, but they lost it, or they didn't, or somebody just didn't put it in. Very, very frustrating. So, again, I've got to now fight to try to get paid on this. Now, what's changed, which I think is a positive, is now we are doing electronic 1696 appointment of representative forms and electronic fee agreements. So instead of sending in paper, it's all done online. So what actually happens is when somebody hires me, we send them a link. We fill out our part of it. We send them a link. They sign it electronically on their phone or their computer. It comes back to me and I sign it electronically, and it's automatically sent into Social Security. Same with the fee agreement. So I'm hoping some of these paperwork issues are resolved, because I've had this happen a couple of times where I win a case early or even later on, I don't get paid because some idiot at Social Security didn't bother putting my fee agreement in there. I had this happen with a hearing where we actually, the case was, I represented the person at the hearing, and somehow or another they never filed my fee agreement in there, even though I'd submitted it in. So I sent a copy of all the paperwork I'd sent to the judge, and basically the regional commissioner said, yes, we're going to say, yes, we acknowledge that you represented the person. Still haven't gotten paid on it, but this is just the paperwork. It's the blizzard of paperwork that just is a real pain in the rear end. And now again, hopefully it's going electronic, it won't be a problem, but now we have to look, every case, do I have the fee agreement in there? Do I have the appointment of representative form in there, so that we know that they are properly seeing all that stuff? So I'm kind of it's a long-winded way to say, but one of the issues you run into when you're doing this on your own is you submit something, it gets lost, because they're dealing with lots and lots of paper and not enough people. And so, again, one of the things that attorneys can do as a practical matter early on is to get that paperwork in directly, because we upload it directly into the electronic folder so it does not get lost. But if you wanted to try this on your own, doesn't offend me, doesn't offend most attorneys who do it, give it a shot. And if you win, you get 100% of your past due benefit. You're not giving up 25% of it. So that's great. If that works, more power to you. I have no problem with that at all. In fact, I talked to a woman just a couple of days ago, yesterday, and she's got I think a pretty good case, and she's telling me that her partner is a lawyer, and she says, we're just going to try it on our own. Like, go for it. Try it in your. I gave her some resources, some things that might help out. She goes, if I get denied, I'll call you. Fine. Again, there's plenty of work out there. I've got, lots of work to do. Obviously, I like good cases, but if somebody can win on their own, more power to you. Okay. Christine, Will stopping opioids hurt my case? I take the max dose of Lyric. I'm worried about addiction, being too heavily sedated, and we lack quality of life. Going to the clinic creates high anxiety. My experience, Christine, is that judges realize, especially if you testify to this effect, that being on long-term opioid use is not a desirable thing. Obviously, it creates the addiction issue. It creates the quality of life. You can't focus and concentrate. It can make you constipated. It can give you stomach upset. So I don't think it is inherently a problem to say, I'm not going to do that. Now, I do think if you're going with no medication at all and your case relies on, or relates to being in severe pain, you're going to have to explain how you dealt with the pain. And again, there are medications that are non-opioid, not maybe as helpful or as strong, or that would alleviate the pain. But I wouldn't say doing nothing. Or if you're taking over-the-counter like Tylenol or Motrin, that's not really consistent with a high level of pain. So there can be a disconnect between going off of opioids, which is very effective manner of pain relief, versus over-the-counter or nothing. But I think that if you explain why you went off the opioids and you are doing something to deal with the pain, whether it's heat or cold or again over-the-counter or maybe some lighter prescription, tramadol, something like that, I think that's not going to necessarily hurt your case, especially if there's objective evidence of medical issues. So in other words, if I have somebody who has herniated disc at L5S1 with radiculopathy, and they decide to go off the opioids, and they manage their pain by really not moving at all, or by ice and heat and things like that, I don't think that's going to make a huge problem with my case, especially if they testify that why they went off opioids, that it was just the side effects were too significant. But I would be concerned if they were on nothing at all. That's how I would answer that question. Sheila Mathis, I had a stroke and have no vision in your right eye. Is that disabling? I would say this, in my experience, losing the sight in one eye is not going to be disabling. It doesn't meet a listing. The listing basically says you've got to have worse than 2200 in the better eye. So, having monocular vision is not inherently disabling. Now, if there are other issues with the stroke, focus, concentration, emotional stability, that may, start eliminating categories of jobs. But yes, having one eye is going to eliminate jobs where you're going to be on ladders, ropes, scaffolds, unprotected heights, moving machinery, hazardous equipment. But what is it to say it's going to stop you from being in a warehouse putting ink pens in a box? And that's the example I always use for how Social Security defines disability. Is imagine a job where you're in a climate-controlled warehouse, you can sit or stand as you need, and your job is to put ink pens in a box. Brainless, warm body kind of job, fog a mirror type of job. Having loss of vision in one eye would not stop that. Again, it would stop some jobs. It would stop jobs involving driving or a forklift, or again, it's dangerous equipment, but it's not going to stop simple, packing type of jobs, things like that. So on its own, loss of vision in one eye, I don't think is enough to get you over the hurdle. There's got to be something more than that. Lady T says, hello, Lady T, how are you doing? Big one. A big one sometimes comes in late, but you made it. Publix, because I mentioned I was in Publix. We have Publix here in Georgia. Yes, it is out of Florida, and that's where they started, but we do have Publix here in Atlanta, at least. It's a really nice place to shop. The people there are very, very helpful. And we have Kroger, we have Whole Foods, we have Trader Joe's, we have a lot of different stores, Aldi. I kind of like to go to Publix because I just think it's a pleasant place to shop. So yes, we do have Publix there, but it is out of Florida. That is correct. All right, Fong Trong, 56-year-old male, DDS medical expert requests a physical examination to see if you're sedentary or light. Is that grid? I think that the consultative evaluation, Fong, is one way to get a determination whether you're limited to sedentary light work. And yes, if you're limited to sedentary or even light, that may make the grids apply. And obviously, if you're limited to sedentary, you have more options under the grid, because you could argue the sedentary grid or the light grid. At 56, I'm sorry, at 56, you can argue sedentary or light. At 50, you just have to argue that you're limited to sedentary. So yeah, I think that that's one of the reasons they're doing it. And I will tell you that I have seen physical medicine consultative evaluations that are either useless, they don't talk at all about somebody's what they call residual functional capacity, where they're limited to light or sedentary, or they are, they go worse than that. They basically say the person doesn't have significant physical limitations. My point here is I would not rely on the DDS consultative evaluation to win your case. It might be enough, and I have seen plenty of consultatives where the person is, by not even by the statement in the consultative, but by the conclusions in terms of the person's capacity, does limit them to light or sedentary. But you'd be surprised how often the consultative doctors don't really understand the way Social Security looks at this, and they don't understand these terms clearly. And we had a consultative doctor, Dr. Foster, on a couple of I think it was November or December, and he talked about all the different tests. And again, he does things his way, and I think he's probably more comprehensive than many consultative doctors. But I see some really garbage results in physical medicine, more so than in mental health. Mental health consultatives usually are fairly decent, but I just see some of these doctors are just terrible. I mean, they're industrial clinic doctors that insurance companies use to deny claims. So I would tell you that I just wouldn't rely on that. If you have your own doctor at the VA or otherwise that would limit you to light or sedentary as Social Security defines those terms, or you go to a physical therapist and get a full-scale functional capacity evaluation to limit you to light or sedentary, that's going to be better. If you can't afford that or you can't do that, then certainly let's see what the consultative evaluation does. But again, my experience has been I don't like to rely on those, because I've just seen too many times where they come back inconclusive or even hurtful. And again, for example, my hearing today, case the judge announced, I'm going to approve this case. If I showed you the consultative evaluation, it basically said this person had the capacity to work. She does not, clearly does not. The judge saw it, and this is a judge with a 33% approval rate. We're not talking about a judge with a high approval rate, but if you looked at that consultative, you'd think this person could work. So I just don't like to rely on those. Hi, Super Lawyer. Well, thank you. Actually, believe it or not, they have this thing called super lawyers, where they have other people, nominate you. So fortunately, I was fortunate enough to be nominated for that. So technically, I am I'm one of those quote unquote super lawyer people. I think it's kind of a big ego thing, and they use it. They try to sell you plaques and books and all this kind of garbage. But it is kind of nice when your peers at least are nice enough to put stuff down there. But I'm not sure if that's what you're referring to. But I did get that honor, which was very nice. Okay, have my SSDI hearing in March. Health conditions cost me my job back in 2000. Self-employed from 2000 to 2020. My conditions are worse, combined with age, 53 now. Okay, so I think a couple things to ask you or to think about would be, number one, were you paying taxes? Do you have enough insurance credits to be insured for disability? You left your job being self-employed. You pay your own taxes. I'm self-employed, so I've got to pay my own taxes. So you want to make sure that you have enough credits to be covered for disability. And what you're looking for is something called your date last insured. And basically, in the disability world, when you're in your 50s, you've got to show that you have worked for at least 5 out of the last 10 years. So when you stop working, your insurance coverage generally follows you for about 5 years. You stop working in 2020, you'll probably be insured for disability through about end of 2025, something like that. But you need to know that date. And if you get your disc, you'll see at the table of contents something called date last insured. That tells you you've got to prove your disability began prior to that date. One of my hearings today, my client's date last insured was in 2020. So I had to prove that he became disabled before then. In his situation, he had had a closed head injury in the military back in 2003 and kind of had gradually declined, but most of the medical evidence is after his date last insured. So I had to argue to the judge that even though the evidence was after that, it really was reflective of his condition, before the date last insured. So that's something I would definitely take a look at. I think number two is the fact that it costs you your job might show that you cannot do past relevant work, but it doesn't mean you can't do anything. So disability is more than just not being able to do your past work. You've got to show you can't do anything. And the third thing I would tell you is that at 53, look at the grid rule for sedentary RFC, or residual functional capacity. Go to gridrules.net, and if you look at the sedentary column, you'll see at age 53, you can be found disabled if you're limited to sedentary work and you have no transferable skills. And I think that's 201.06, if I'm not mistaken. And basically what you're saying is that the combined effect of pain or medications would make it impossible for me to focus and concentrate at past work or anything else. So any skills I might have acquired won't transfer. Therefore, I don't have the capacity to transfer my skills. I'm limited to sedentary. I meet the grids, assuming you have a physical limitation. In the alternative, as we talked about before, the combined effect of my medical issues and medications would leave me without the capacity to do any kind of work at all. And obviously, Social Security recognizes that people over age 50 are going to have a more difficult time adapting to different work or finding entry-level unskilled work in the economy because employers are looking for younger people for those entry-level positions. So it is a reflection in Social Security. But that's the three things I would look at is your date last insured. I would keep in mind that you're not just looking at past work. It's really about anything at all. Look at the grid rules and make that grid rule argument as well as a functional capacity argument. Hope that gives you some guidance there. Christine, I think you've asked this before about the opioids. I hope we did ask it. Okay. The dude is here with a emoji with sunglasses. Okay. Ryan, he's the one who said he was self-employed. I think with self-employed, again, some of the other considerations that come into play would be, number one, that as self-employed, you might have more skills than you think because you've run a business, you've perhaps dealt with payroll, you've had to deal with marketing, so you might have skills beyond the actual, occupation you did. So that's one thing to think about. Number two, if your business is still generating income, let's say you have somebody else running it, you're going to have to explain why you are not the person. You're not doing anything in the business. I had a client one time who had a karate studio, and she was running it and had some medical issues, and she turned it over to her son, but it was still the earnings were coming in under her social. We had to prove with some documentation and the accountant and her son testifying that she was not physically doing anything, and we had to get it out. We had to change it so that all the earnings came to her son's Social Security number. So that could be another issue there. Again, I think that people who are self-employed, there may be an element where a judge might say, well, you are not, you're an entrepreneur, a hustler, and so how do I know you're not doing something under the table for cash? And you may have to get past that presumption. But I don't think other than that, there's any issue with being self-employed. RB says, West Virginia is lengthy for SSDI approval. Why even have a recon phase when all they're going to do is deny? RB, you make a very, very good point. In fact, over the years, and I've been doing this for about 33, 34 years now, there have been pilot programs where Social Security eliminated recon as part of the process because all it does is delay everything by another, now sometimes 8-9 months. It is a waste of time. I mean, statistically, at the initial, which is really mostly going to be listing or grid kind of cases, about 35%, and these are last year's, they call it the waterfall chart, about 35% of initial applications are approved. The people that appeal and realize that not everybody appeals, and they bank on that to some degree, because people give up. But of those who appeal and they go to recon, the recon appeal, only about 15, 16% of those cases are approved at recon. Then those who appeal, again, there's going to be a drop off. Certain people don't appeal, but the ones that do appeal to a hearing, now we're getting close to 50%. So you have 35%, which again, a lot of them are, life limiting, severe, significant problems. Then recon is like 15%, 16%. Hearing is at 50%. And again, I think what's going on is that Social Security, is part of their calculations in terms of the analysis about the money they have to lay out. They want people to give up. I don't think there's any doubt they want people to give up, and they discourage people by the long delays, and the recon does just cause more delay. But I would agree with you, it's kind of a waste of time. They really just need to get rid of it. What happens at recon is you file your application, it goes to an adjudicator at the state agency under contract with the federal government. The adjudicator develops a record and then makes a decision, sends it to you, denied. You file the recon appeal, it goes back to the state agency, the same people who just denied you, with a different adjudicator. They don't have enough people as it is now. Why not put all the adjudicators working on initial, and if they deny you an initial, go right to a hearing? That would make sense. But, we're talking about the dysfunctional universe of Social Security, but I don't disagree, RB. I think that recon is kind of a waste of time. Michael Robert Jennings, is it possible to hire me for a consultation? I do a little bit of that. If you go to jonathanginsberg.com, it's ERG, by the way, jonathanginsberg.com. There is a link there where people can hire me for a half hour, for an hour. I don't have a lot of time to do that, but I mean, I'll do it on selected things. But I would tell you, if somebody wants, kind of to run something by me, or something, there's some questions about something, email me first. SSD answers 123 at Gmail is the best email. Just email me, let me know what you want, or just fill out one of the forms on ssdanswers.com and just tell me what you want. I'll send you back and we can talk about whether or not it makes sense to hire me, where I can just answer your question really quickly. But I do a little bit of that, usually a couple $100. But I'd rather spend my time working on my cases, so I'm not going to put a lot of time into that. But sometimes people do have some questions, so I do that. But just email me and I'll tell me what you want, and we can talk about that further. And again, Jonathan, or just ssdanswers.com, go there and just fill out the form and just say I want to talk to you about an hourly thing, or email me ssdanswers123 at Gmail and tell me what you want, and we can continue that discussion by email. Essay. So you're saying that the judge won't see you, but will hear you. You're on the phone in a three-way or more. You rehearse with the client. Yes. So basically what happens is, in a telephone hearing, there are 5 people on the call. Myself, my client, the judge, the vocational witness, and the hearing assistant. They do record these hearings. But the judge, here's me, here's my client. The hearing is done by telephone, and many, court systems are using telephone hearings. I find that it works quite well. Everybody's in a comfortable environment. The judge is typically at home or in his office or her office. There's not people hacking and coughing. My client's at home where they're comfortable. I'm, like I'm wearing a sweatshirt and jeans right now. That's how I'm dressed. They work pretty well. Some people want video. Again, one of my hearings today was video. They use Microsoft Teams for video. So if you wanted to see the judge and be seen, you can do a video hearing. You can choose that. You could do live hearings. The problem with live hearings is, in my opinion, that right now, at least, they're still very concerned about germs. And so what's happening is, whereas it used to be back before COVID, you would go to a hearing office and you'd be in a waiting area, and there might be 40 or 50 people there, and there might be 7 or 8 judges holding hearings at any one time, at least in Atlanta, let's say. And so you might have, a judge might have a 2, a 3, and a 4. And so you'd have, people for all those different hearings. Well, the problem is you got 40, 50, and of course they're bringing their kids and they're bringing their parents and their friends. You have 40, 50 people in a room, and you got people that are coughing and hacking and all that stuff. It's a germ factory. And then, you go into this small room with the judge and people, and it's just the claimant, obviously, and the attorney, but you got people in a small room. If they may be sick or they may be carrying something. So I think judges don't really like them. And so now what they've done is if you do a live hearing, they do them one at a time. So, they may schedule an 11 o'clock hearing but only one judge will do it. And then there'll be a 12 o'clock. So it just takes a lot longer to get a live hearing. That's been one of the big issues there. So it's not as efficient. So I would say that telephone works great. There's not a lot of technical issues. Video can work well as long as you understand how to use Microsoft Teams. Again, my case today, my client had a laptop, worked perfectly fine. But yeah, it's basically everybody's on the phone. And judges are used to doing it that way. I'm used to doing it that way. And look, honestly, the hearings last 45 minutes, mostly about the medical record. It really is. What you say is marginally valuable. What the attorney says, I'm going to do it in a brief typically, as opposed to my even opening statement now. So it's really just a matter for the judge to ask a few questions just to clarify things. So yeah, these hearings work really well with telephone. Okay. All right. So this is going back to St. Louis. Grand was asking about, got a remand from federal court and the hearing is not scheduled for 3 or 4 months. And I said, you might want to submit a waiver. He said he did submit the waiver. The rep said something, they don't really honor that. I don't agree with that. They do honor that. I mean, again, the hearing's already scheduled. So I think, again, the better strategy there would be to reach out to the judge and say, I'm available within 2 days' notice. At any time in between now and then, if you can squeeze me in. And I would explain why. Financial hardship, living on couch surfing, I lost my house, whatever it may be. I have a case right now where I have a client who basically is going to be homeless. So we submitted the 75-day letter. We let them know that he's about to be homeless. Lo and behold, we got a hearing date. So, sometimes that will happen. Okay, Randy. Wish your team would communicate better, know what the status of the case is, unfinished form. All right, Randy, again, I know we've communicated by email back and forth. I will tell you, in the last part of the year in December, I was out, but you should have gotten some communication from Jen. I will follow up with that, but I know everything got filed. And, we should be in pretty good shape. But if you sent something to me or to Jen, and anything you send to me should be copied to Jen, I'll make sure that we do respond to it. But I'm sorry you are having communication issues. But again, not to make excuses, I was from right at Christmas through this past Saturday, I was out of town. I wasn't really doing a whole lot of work. 2 or 3 hours a day, just kind of responding to emails as I could, but I just needed a break, got to clear my mind. So we will get on that. Mark is one of my clients. How are you doing, Mark? Hope you're doing well. I think we've already talked about that one there. Paul Nightwolf. When you hit age 55, did the reviews go longer? Like every 3 years, now it's 5 years. Yeah, I think that that's a very good question. I think that when you hit age 55, the frequency and the likelihood of a continuing disability review does go down because you're getting close to retirement Social Security, and the odds of you getting significantly better quickly at 55 and over are not great. So I think that the likelihood of a review goes down. Now I realize that some of the review letters are generated if they see earnings. So if there are earnings, that can be it. There's a randomness to it. But generally speaking, everything else being equal, a 55, 56-year-old is less likely to have a review than a 35-year-old. The goal for Social Security is to get people who are 35 back in the workforce and to to reduce the number of active claimants. And I suspect that we're going to see more of that with new commissioner, new administration. But I think those of us over 55 will have less of an issue there. Does a back case have to have muscle weakness someplace? I think if you are alleging musculoskeletal issues, there's going to have to be some issue, whether it's weakness or pain, but there needs to be objective evidence of something going on in your back. Yes, I don't think, I don't know what else it would be. Muscle weakness, I mean, I guess you can have pain without weakness, but inherently, if you have severe pain, you're going to be less inclined to do physical stuff. So, so maybe that's what you're getting at. But I think that, if there's not weakness, that's going to make it harder to reduce that functional capacity to sedentary or light. So I think that to answer the question, I would say, yes, you need to have some weakness if you're arguing a back pain type of case. Okay, a hidden got approved SSI, got a hearing schedule for SSDI. Okay, not exactly sure what you're asking, but yeah, because hearings are done virtually, does not matter where your lawyer is. I had a hearing today. I'm in Atlanta. One of my clients was in Florida. One of them was someplace on the East Coast. I think in Tennessee. I think doesn't really matter where you are. I don't, just because it's all done by phone or video. So yeah. So if you are got approved for SSI, which does happen sometimes. Now there's the SSDI component to it. You've moved this. The lawyer can do it as long as the hearing is done virtually, unless the lawyer wants to travel. I know Jen. We always joke. We have a client in Hawaii, and she's like, "Well, I'll volunteer to go to Hawaii to work on that case." Like, okay, but yeah, it does not matter where you are. It's all done. If it's done virtually, it doesn't matter. I'm a retired disabled firefighter in Florida. Received a pension through FERS. Also received SSD and paid a social for 26 years. Has the new Fairness Act affect me? The Fairness Act, basically, which just got signed this week, eliminates this offset where you can get Social Security and other federal benefits. I've really not studied it, so I don't want to comment on it. It does make Social Security more available to people getting other federal programs. So I think that in big picture, I'm going to say it likely benefits you or has no effect at all on you, but it's not going to hurt you if that's what you're asking. So maybe I'll get somebody on who can talk more about that. But it's basically a move by the Social Security, by the government, by Congress to make more people eligible and not have offsets for other federal programs. Okay, but I'll see if I can get more about that. Maybe I'll do a video or a blog post about that because again, it doesn't really impact what I do on a day-to-day basis. But I think it's probably something people are asking about, so I'll get some more information about that in the next few weeks or so. Hello from New York City. I suspect it's pretty cold up there. Have a video appointment or a hearing soon. Have lumbar bulging, disc, fibromyalgia, diabetes, and carpal tunnel. Also walk with a walker. Someone's a cane. Have a tenant 23 hours weekly. What are the odds of winning? I think pretty good. Now, again, I don't know. You didn't say how old you are, but if you've got diagnosed objective problems, the fibro to me is going to be less compelling. But you use a walker and a cane. If you're over 50, certainly look at the grid rules. So again, depending on how old you are, the facts seem pretty good to me, is what I would say. But I would say if you're over 50, they look really good. Over 55, really, really good. Under 50, decent. But if you're 25, it's going to be a little more difficult. But I think the fact that you're using a cane and need a home attendant, yeah, that sounds pretty serious. I think you've got a pretty strong chance of winning. Cassandra says, I'm having a hard time getting SOT from my minor child. He was on, but they cut him off. I don't understand, because if you are on, SSDI, minor child's not going to qualify for SSDI unless they're an auxiliary. In other words, SSDI is based on an earnings record, and a minor child is not likely to have an earnings record. Minor child might be on SSI, but probably not SSDI. So if you're asking, your minor child was cut off for auxiliary benefits based on your benefit, that doesn't make sense why they would be cut off. If your child was getting SSI, they might have gotten cut off because of, income and resources. But I don't understand why your minor child would be on SSDI in the first place. Unfortunately doesn't make any sense to me. Yvette says, okay. Josh would say, thank you. I don't use my real name. I think I know who you are, Yvette. But you worked in my case, reconsideration approved. Yes, absolutely. That's a good thing. That's a really good thing. We love early approvals. And, sometimes I have people say things like, well, attorneys will intentionally delay it because they want to get paid more money. BS. We want to get cases approved as quickly as possible. And, whenever I do an application or an appeal, I always try to put in there, if I can make an argument for approval, I'll put it in there. And again, if you are who I think you are, then I think that's what we did here. And I'm thrilled that we got it approved early. That's great. Erith, I'm sorry, is 59. So yeah, I think that, based on what you said before, all these things, you're 59. I think the grids apply. You're in a walker. I think you've got a very, very strong case. Okay, does a back pain have to show nerve impingement with that nerve conduction? Not always. I mean, it certainly helps. I would say, whenever you have a back pain case, you've got to show loss of function. And, function, why is there going to be loss of function? It's because some of the nerves in the spinal canal are not functioning entirely properly. A bulging disc without any sort of spinal cord impingement or stenosis or nerve impairment, it's probably not going to be symptomatic. So, you've got to show enough of a pathology that it is symptomatic. That's what I would say. So it doesn't have to have, abnormal EMG or anything like that, but there needs to be something there that shows why you'd be having problems with functioning. Because remember, disability is about your capacity to function. What besides a nerve conduction cast improve an electric foot? Isn't pins and needles? The EMG is going to be the gold standard for that. Now, again, an MRI might show, some impingement or something that would explain it. But the EMG, in terms of the nerve issue, that's going to be your gold standard. So if that's not showing anything, you could have what they call idiopathic neuropathy. I had one of my cases today. My client, one of his conditions was idiopathic neuropathy, where he basically says, I cannot feel my feet, but the nerve conduction tests were, were basically mostly normal. So the doctor diagnosed idiopathic, which means no explanation, neuropathy. That may be going on there. Or again, the MRI might show something, but if the doctor says idiopathic neuropathy, that can be a reason why you have the pins and needles, and that diagnosis can carry weight if the doctor believes it. Okay, by all. Thank you. You're welcome. Question about the adult function test. Let me find the rest of your comment here. I'm not seeing it there. Okay. If I get back to it, it says 1 of 2, but I don't see the second part of it. Conflicting information. Let me just take one more quick look and see. Oh, here we go. Okay. After leaving my full-time career, I tried 4 different part-time entry-level jobs, failed them all. Is this enough to demonstrate I'm able to do other types of work? It's evidence. I don't think it's proof. I mean, I think it is evidence you tried to work, you're not able to do so. But I think there's got to be medical evidence to explain why you're not able to do past work or any of that kind of work. But failure, unsuccessful work attempts, that's certainly evidence. If you can get statements from former coworkers or supervisors describing the problems you had, that would help. But ultimately, you've got to have medical evidence, MRI, CT, ultrasound, EMG, whatever the case may be. But just, the fact that you weren't able to do the work is not dispositive of the question whether you can or not. I mean, there's any number of reasons somebody would lose a job, performance, capacity, some of them, but could be other things. I mean, people even lose a job because they move or the company shuts down, or they didn't like somebody. I mean, there's any number of reasons. So that is a factor. And actually, I think it's a very relevant factor. I use it a lot. I think it shows credibility. If you are trying to work 4 different times and you're not able to do so, and you testify about the struggles you had, I think that can be non-medical evidence, very compelling, but I don't think that alone is going to be enough. Okay, let me go back up here to where you were before. Explore with me. Had 5 surgeries on the hands. Still continue to drop things and bothersome. Kind of get a disability check for this. Well, first of all, is it both hands or one hand? And how functionally damaged are your hands? You drop things. What is, are you in pain? Do you have any capacity? Can you press a button? Could you answer a phone? And let me also say this. So your question is, and I suspect it's the way you wrote it, but can I get a disability check for this? I think, that suggests that let me put it in the affirmative way. You always go into disability cases with the idea you don't want to be disabled. You want to be working. You want to be, interacting with your coworkers and the public. When you say I want to get a disability check, that kind of sounds like you've given up, and that comes through. So I think that if Social Security or you say to the judge, how do I get my check? That looks like that you are motivated to be disabled as opposed to motivated to go back to work. And I don't mean that in a mean way. I'm just saying that's what they pick up on. That works against you. So I would say that's probably not the way to phrase it. But to answer your question, you've had surgeries, that shows there's something there. You've dropped things, that shows you've got loss of grip strength. But what is it bilateral? Number one. Number two, do you have any function left at all in your hands? Is it likely to get restored? Are there any minimal assistive devices, braces, things like that would help you? Are there jobs that you could do? And the way that Social Security looks at it would be, if a person's, has would need to avoid jobs that requires, fine motor manipulation, would be limited to occasional use of the hands for fine or gross motor manipulation. Occasionally means 2 to 3 hours in a day. There are jobs that you could do. So you would really have to prove that you can't use your hands for even 2 to 3 hours in a day. So you'll need medical evidence for that. But I think having 5 surgeries, carpal tunnel, maybe trigger finger, does show a significant problem. But what is the residual? Remember, residual functional capacity. What is the residual effect of, all those surgeries on your functioning with your hand? Metal Mike. I'm schizoaffective. Asked question before. The judge and I, SSI for meds aren't working. Want to do therapy instead of meds. The side effects are too bad. I would tell you, Metal Mike, in a case with schizophrenia, schizoaffective disorder, the only real treatment, the primary treatment that people have are medication. And if you sort of decide, I don't want the medications because of the side effects, most judges, in my experience, are going to say that you are not being, cooperative. You're not, what's the word I'm looking for? Compliant. You're not being compliant with prescribed medical treatment. So, it's a problem. It's a conundrum because on one hand, the medication side effects are unpleasant. They make you feel like a zombie. You basically can't focus and think. You're sleeping all the time. On the other hand, if you voluntarily stop taking medication, then your schizoaffective symptoms are going to be worse. And the question the judge would have be, well, if you're on medications, would you be able to function. Now, I think the fact that you're talking about going through therapy, I assume you mean talk therapy, that shows you're trying to do something else. But I would probably tell you that you need to be weaning off of the medications, the psychotropic medications, with under the guidance of a psychiatrist, and kind of easing into that. But I don't know. I know people with schizoaffective disorder, sometimes they do shock therapy. There's different number, although not as often anymore, but there are different things they can do. But not taking any medications when you're schizoaffective, I think that's going to be a hard sell with most judges, honestly. That's my take. But I would talk to your psychiatrist and see if you can get some guidance and some support in weaning off the medications, which I have no doubt are causing significant problems. How long after approval does it take to get payment? If you get your favorable decision, I've seen it come in as little as a week. I tell people 3 to 4 weeks, but I've seen it happen in a week. I had a hearing I did middle of December, right before I left, and I got paid the first week in January. So my client did as well. So within 2 weeks of the hearing, which is pretty good. I think I did read your question here, which is this one, pension through, as far as, okay, the Fairness Act. I'm going to try to get something out on that. I don't want to speak to it because I don't have I've not studied it. But again, I think in general, it is going to be a fairly positive thing for people trying to get on benefits. Tom says, love my show. Great. Thank you. Lost your hearing. I'm sorry. That's not good. Not having RFCs or functional capacity forms completed. Such a mistake. All the way to step 5, not getting this evidence. And I wonder, not appealing hurts my case. Should I go ahead and apply again? I would exhaust your administrative appeal before applying again. And here's why. If there is evidence that existed or you can get that would have made a difference, that may be something you could present to the appeals council. If you apply again, a couple things to worry about. One is your onset date would be the day after the unfavorable decision. So all those past due benefits going back 2-3 years are gone. Maybe a date last insured problem. So you may not be insured. You need to look at the unfavorable. It'll tell you what your date last insured is. I will speak for myself. If somebody contacts me and says, I got denied, I want to reapply again, I'm going to say, what is new? Because if you go through the process again, it's going to go to the same judge. If nothing new, and I mean a new condition has occurred, you're going to get the same result. And again, maybe having those functional capacity forms makes a difference, but the judge might say, I've already made a decision about that, about the severity of his condition, and I've decided it's not severe enough. So before I would apply again, if you're within the 60 days, talk to somebody about doing an appeal. And there are people, and I can give you some names if you'd like, that do nothing but appeals counsel and district court work. And if you want to talk to one of them, I usually co-counsel. In my cases, I'll co-counsel with one of them. But if you email me, and I can put you in touch with somebody if you don't already have somebody, and that might be something at least to look at before looking at reapplying again or applying again. Okay, dogs are me 100. I'm 33, meet the listing for cerebral palsy. Currently, my late father's SSDI. I feel that voluntary work would be very helpful for my mental health. And so what you're saying is you are a disabled adult child collecting SSDI based on your parents, your late father's status as a disabled person, retired person, or it sounds like disabled person. Volunteer work. And I don't disagree with you. I think that what you have to be careful about is, does that volunteer work rise to the level of substantial gainful activity? If you're not being paid for it, obviously there won't be any earnings record, but if you're, let's say, doing something 6 or 8 hours a day, 4 days a week, that starts to smell like a job. So, or a substantial gainful activity. So I would be very careful about how much time you put into the volunteer work. I realize it's therapeutic. I admire you for wanting to do something because, yeah, it's better than sitting around at home. But just be aware that when you do that, if you should be reviewed and they see you're doing something, you're volunteering at a library or a museum or something like that for 4 days a week, 7 hours a day, starts to look like equivalent to a job. And that would be, again, substantial gainful activity. It doesn't need to be paid work. It can be unpaid work as well. Oh, no, I forgot to do here. I forgot to put in my little banner here. Sure, my buddy Garrett's going to be unhappy about that. Okay, so I put that in there. Sorry about that. Got to put that in there so people know how to get a hold of me. Okay. Should I meet in fact, I meet a listing. Should I worry about it? Look, even all the listings have a functional element to them. So even if you meet a listing medically, and CP obviously is a listing level condition, but it's got to interfere with your functioning. You could have, congestive heart failure at a listing level, but if you're able to work, you're not disabled. Same with CP. You could have, diagnosed CP at a medically, disorganization of arms and legs and gait and things like that. But if you're able to work, you're not disabled. So I think that even if you meet a listing, it's less likely you're going to be reviewed. They'll probably mark it as one where improvement is not very likely. But again, if they should do a review, and they might do them because you're 33 and you're doing something 4 or 5 days a week, could be a problem. So I would probably tell you to limit your volunteer work to, maybe 3 days of work, not full, maybe 4 or 5 hours a day, something that is less than what a job would be. And maybe even get from your doctor some sort of a statement to the effect of, this is the most I want my patient doing. Because, otherwise he could hurt himself. This is the maximum of his capacity. That covers you in case there was a kind of a review. I'm 49 years old, says David, been denied voice to Bakersfield. I don't know what that means, voice to Bakersfield. SSI department. I don't know. If you say you've been 49, you've been denied, and your initial recon, then you could appeal, but I'm not sure. I apologize, David. I don't know what you're really asking me there. Maybe you could jump back on and be more specific. Okay, here's some more from David. Needs to know right one to require full evaluation, disposition, chemist, getting voice. I was victim. I'm sorry, David. I don't quite understand what you're getting at. I don't understand your question. I apologize. It's just not making sense to me. 49 has been denied voice to Bakersfield. Then needs to know the right one. I don't know what you're asking me. Maybe if somebody else understands what he's asking, please jump in, because I just don't understand it. Ms. Crystal, I have a hearing coming up next week. So nervous. My attorney told me over 60 medical exhibits. What does that mean? It means that there's the electronic folder. It used to be physical folders. Section F has 60 exhibits. 1F, 2F, 3F, up to 60F. Obviously, there's a lot of medical evidence there. Again, what does it say? Having 60 exhibits doesn't mean you're disabled, but it suggests there's a significant medical problem there. What does it say? Again, if you're 60, I don't know how old you are, 60, but it just says 60 medical exhibits. It just means that if the file is comprehensive and large, and that usually, not always, usually translates into a fairly significant medical case. I would say that's a general rule. Not always, but it could. All right, Madeline from my office. Hello, Madeline. How are you doing? Madeline and I email or text frequently during the week. Sometimes we talk, but a lot of times just by text. She is a call screener and works on cases as well. But Madeline has a very good eye for knowing what to ask, and we've had to keep changing that because Social Security keeps changing. But she does a really good job for me, and I'm glad that you're here. Thanks, Madeline, for jumping in. Fowd. If you're approved to the Appeals Council, do you get back pay since the onset date when you were disabled if you win at the hearing. Now realize most of the time, not all the time, but most of the time, if the appeals council or federal court finds in your favor, they remand, R-E-M-A-N-D, they remand the case back to a judge for another hearing. Rarely, it does happen, rarely they will actually approve your claim and find you disabled. But I would look closely at what the Federal Court of the Appeals Council says. It's probably going to be a remand, which means it goes back to another hearing. Doesn't mean you're going to automatically win. Many judges will approve you, but doesn't mean you're going to win. So I would look at the language of it. Okay, if it's my legs, balance, motor skills, pace of work, that would leave me very limited, possible 40 hours in the transportation, which does, right, transportation does not matter. Right, so I mean, I think that those issues, let me see, let me go back to, so Dogs and Me is the 33-year-old with CP. Yeah, no, I hear you. And again, what you're saying is that logically, the medical issues would limit you significantly to work 40 hours a week. But if you go and do something, okay, and it is in the mind of Social Security, the hive mind, a judge, an adjudicator, roughly equivalent to work, they could reach the conclusion that you have the capacity. In other words, let's say you're working 30 hours a week. They could say that is evidence of capacity. Why don't we assume he could do 40 hours a week? So I just don't think you should assume that because you're listing level, but you're doing activity and you're 33 means that you are, insulated from any kind of review. I just think you got to be, especially now, we're going to have, I suspect, over the next few years, a less friendly Social Security Administration to claimants. So I would just tell you to be careful. That's what I would leave it at. Okay. K-Wolf, you are welcome. Thank you for, my pleasure. I enjoy, these are fun for me. I enjoy doing it. It's a chance for me to answer questions kind of live. I've got some great guests coming up. I've got an appellate specialist coming up. I've got a judge coming up. So we're going to have some good stuff coming up here. David says, in February of 2020, a car hit you twice. No lawyer, Justice League, help non-state bar, please reply. David, you're kind of talking stream of consciousness, so I don't quite understand. I need you to be more specific as to what you're asking, because you're making statements, but they don't really line up, and maybe that is part of the underlying issue there. But if you were in if you got hit in a car where you're a pedestrian, or another car, I don't know. SSA was diagnosed with metastatic breast cancer in 2015. Refused chemo, no clinical signs of cancer since. Again, if there's no, you might be one of the really lucky people who the cancer spontaneously disappeared. A diagnosis does not make you disabled. So you could have, herniated disc, cerebral palsy, like this other gentleman, doesn't make you disabled. What makes you disabled is the effect of the underlying symptoms, medications, things like that, the effect of all that on your capacity to work. So, the listings even have, as I mentioned, a functional component to them. So yes, metastatic breast cancer is a listing level condition, but if it has gone away and there's no ongoing problems and you're cancer free, no signs, no anything, I don't know if you said you're cancer free, but no clinical signs, you're not having any problems, the question they're going to ask is, well, why can't you work? You were diagnosed 10 years ago, but you've got no functional limitations. Why aren't you not working? If you're able to work, by definition, you're not disabled. Joey Armstrong, myself is that you are who another at the Spend Y Road did. Okay, this sounds like, I don't know, Joey, I'm not sure if this is, I don't know what that is, but okay. I can't answer that. David, I filed and no one looking my house. Okay, David, again, I don't mean to be rude, but I don't understand what you're asking, so I'm not going to respond to it. TBI survivor here. And I think traumatic brain injuries, again, my case today was one, can be extremely debilitating depending on what the symptoms are. And it could be migraine headaches, it could be problems with focus and concentration, memory issues, emotional instability, anger control issues. It can lead to a lot of significant functional issues. And I suspect if you've got one, you know, but that's really the question is, what are the functional issues that arise from your case? Tony Mimi, good evening, watching from North Carolina. You're probably going to get colder than me. First time watching, been subscribed to your channel. Great. Well, I'm glad you've been subscribing, and I'm glad you find it helpful, and welcome. I hope to see you here in weeks to come. Let's see here. Primary doctors are writing bilateral breast cancer with high chance of metastasis. Again, with breast cancer, there are going to be certain treatments, whether it's radiation or chemo, that are typically done. If you choose not to do them, obviously there's a greater chance that you will have negative effects, metastasis of the cancer. But, if you don't do them and there's nothing happens and you're still able to function, you're not disabled. Having that diagnosis does not make you disabled if there's no functional limitations. Okay. Where can I find a warm body job, says RB? And that's a very, very good question, and a reasonable question, because what you're getting at is, Social Security says you're not disabled if you can perform a warm body job. They're not obligated to find you one. And as judges will say at hearings, the fact, the jobs that we talk about in the vocational testimony, there may not be a job anywhere near where you live. You may not be able to survive economically on that job. You may not have transportation to the job. They're saying theoretically, if there is a job out there you could do, you are not disabled. Is that reasonable? Is that fair? Absolutely not. But they're saying if there is a packing job in an air-conditioned warehouse, 100 miles from you, and you can do it, you are not disabled. The question, they look at it, are there jobs in the economy, the national economy, the regional economy? So, you may live in the middle of nowhere and there's nothing near you, no bus line or anything. It doesn't matter. The way Social Security looks at it is, it doesn't matter you can't get there, it doesn't matter you can't get from there, it doesn't matter you can't get from the parking lot to the job site. If you got magically transported, into the work site, could you perform the job? That's really the only question. Laura says, I submitted my initial application, 57 years old. Laura, we talked earlier, or referred to her question earlier. Drop off updated medical records at SSA for 46 weeks. Should I highlight the important doctor's notes? Yes, and yes. Highlight the important doctor's notes. Highlight the grid rule. I would, if I were you, if you've got the adjudicator's fax number, fax them a letter. And if you don't know how to do that, go to SSA.gov / I think it's SSA.gov/locator. Let me just take a look. SSA.gov/locator. Yes. So if you go to SSA.gov/locator, LOCATOR, you put your zip code in, you'll get the fax number of where you can fax things. But I would put in your letter, please evaluate my case under grid rule 202.06, 201.06. Please be advised I have faxed you the following records or submitted the following records, drop them off. By the way, if when you go to drop them off, ask them for what they call a barcode. That way it gets associated with your file. That might help a little bit. But yes, the more you communicate with them, the better. And yes, highlight it is absolutely correct. That's what you want to do. Hey there, who, me, or you, says Courtney. Okay. How come SSA isn't getting VA medical records? Not that they don't like to get them. They can get them through the HIT system, the Health Information Technology. But VA records are voluminous. They're very difficult to read because there's a lot of duplications in there. And so when I have a file with VA records, and maybe 700 or 800 pages on the exhibit, it's a pain in the rear end to go through. So I think that, adjudicators and judges aren't fond of them because there's a lot of fluff in there, and, 400 pages of records and 20 pages of relevant record is what I would say. Okay, and David, I know you've submitted a bunch of comments. I'm not getting a question, so I can't really answer you. I think you've got to, if you can't, and again, maybe this is part of the underlying problem. If you need to get somebody to kind of summarize what you're asking, feel free to email me, but these statements aren't making a lot of sense. And again, I don't doubt your sincerity, but I can't help you if I don't understand what you're asking. Primary care, is it for mental health? I think if you're asking whether primary care can be a good resource to talk about mental health, not really. I mean, I think that mental health, you're better off with a specialist like a psychologist or psychiatrist. I'm not a big fan of primary care doctors making assessments of depression or anxiety or PTSD, things like that. Judges don't find it compelling either. SSDI or CDR, you got schizoaffective at a hearing, never worked. A patient says no medical improvement. We're going to favor, again, depends on the judge. Without looking at the evidence, I would say, I can't say. I think that if you've got a firm diagnosis, you've not worked, the medical evidence says there's been no improvement, you should win. But, I hate to answer questions like this because, without looking at the records and not knowing who the judge is, what the percentage of approval for the judge, I would not know. But I'm guessing what you're saying, it sounds hopeful. I'm 57 with multiple back and mental conditions, applied December 12th, 23. So it's been over a year. I have medical CE on February 4th, mental CE on February 11th. Too late? No, it's not too late. You can get representation at any point in time. And I tell people, again, I'll tell you the same thing I would tell you if we were talking on the phone. You applied in December of 23, you're probably getting close to a decision. The CEs are going to be what the CEs are. They're going to either help you or hurt you or make no effect. You're probably going to get a decision March or April. Maybe you wait until you get a denial before you hire somebody because, quite frankly, if you're going to win, you're at the point now where it's been a long time. And, what I would do here is I would reach out to my representative, senator, and say, it's been over a year. Will you do a congressional inquiry? Just get a decision. This is, honestly, you're probably better off. I'd rather you get 100% of your past due benefit. If you hire me or somebody like me, you're going to pay 25% of it. You're so close to getting a decision, just wait. I would tell you to wait. Not too late, you can do it, but I would tell you just go through the CEs and just hopefully get a decision in the next couple of months. And if you get turned down, I think, you're 57 with multiple problems. You got a good argument on its face. I'd be happy to chat with you about that. Reach out to me. But yeah, why don't you try to get 100% of your past due benefits? I'd rather you get the money than pay me, quite frankly. So, okay. Let's see here. And David, I know you're sending other emails, but I can't respond to them because I don't know what you're asking me here. Okay. Does DDS use the grid rules? Asked Lulu. Yes, they do. Now, not every adjudicator fully understands how they work, but they do use them. And I have won cases at DDS under the grids. And in fact, when I do an appeal, I will put in the remarks, please evaluate under grid rule 202.06. And sometimes it does happen. Okay. Courtney, let's see what we got here. Well, there's been a problem. I've been eating well, been evicted. This is the payments by doctor. Okay. I don't know what that's getting at. What was the website address if you made a listing? Well, my website, it's my law firm's website I put together. I created it, called meetalisting.com. And it gives you a link to the listings, and it gives you examples of how the listings, work, some case studies. But meetalisting.com. Let me put it on the screen here so you can see it, so you recognize it. Let's share the screen. Share screen here. All right, so this is what the website looks like. It's called metalisting.com, as you can see up there. If you can see that or not, but metalisting.com, and it links to the listings. There's the listings here, and I've got, I talk about how to win, what you need to know about them, and how to use the listings. And I think I have some examples of this here. A case study, I got a couple of case studies there. But yeah, this just gives you an easy way to look at the listing. You can ask for a case evaluation, but yeah, this is just a simple way. This just links to Social Security's Blue Book, honestly, is what it does, but it's just a little bit easier to use than the Blue Book directly. So I just have it out there, and people will bookmark it. A lot of other attorneys use it to kind of bookmark. So that's what it looks like. But that is the website, Meet a Listing, MEETA listing.com. Let me see if I've got it over here. I do not. Okay. I'll put it up there soon. Stop sharing. Okay. Go back to our comments here. Will SSD get any of the money from Fairness Act? I don't understand the question. I don't want to comment more about the Fairness Act because I haven't really studied it. Tat says, look for an email. I will. I know you will send me an email. Okay. Okay, not anybody it says the live stream consider surviving spouse, SSDI, but SSA entered my claim over a year ago. Again, I think if I'm not mistaken, you're in Texas, and that is a slow one. But yeah, we'll. I don't want to talk about your case, obviously, live, but send me an email and I'll respond to it. Okay, so Sabrina says, in Texas, reached out to our senator in Texas a couple months ago. I think months ago. Husband was approved 1 month ago. It took 11 months total. See, you reach out to your elected representatives, let them be good for something other than spending our tax dollars, so they can make an inquiry. And lo and behold, Sabrina her husband got approved or got relief. That is good. So it does work, and I've had this work for a lot of my clients, reaching out to their representative. Leave me, you know what, Sabrina, leave me a review. If you got this for me, leave me a review. Let me put it on there, how to do that. There we go. Okay. Let's see what we got here. Okay. Exquisite. I'm 51. I was given a 5 to 7 year review at the 5-year mark of December. What's the likelihood? They're so backlogged. I can't give you a percentage. It could happen, but I don't want to guess because I just don't know. But I suspect that because they said 3 to 5 to 7 year review doesn't mean it will happen, but you're in the range now. You're also 51. So I would be aware and alert to it, but don't assume it's going to happen anytime soon. Can somebody outside the country with family waiting for a hearing? Yes, you can. Now, I've got clients in other countries, and the question would be, if you're getting medical treatment, we have to get the medical records. I have one coming up in a couple of weeks. Clients, and I forget where, but we've got to get those medical records, and if they're in a different language, you got to get them translated. So, it can be an issue there. Let's see. An attorney with this revenue huge client tempo has good communication in his office, not too cool to bring up on the plate form. Okay. Not sure what that means. And look, Social Security is a big bureaucracy. Things take a really long time. And, we're to some degree at their mercy. I mean, we can't force adjudicators to make decisions. We can't force them to schedule hearings. We can't force them to do anything. All we can do is make the information available and be there when they do act and react to it. So, hiring an attorney, whether it's from anybody else, does not give you a automatic, it doesn't speed things up, it doesn't do anything other than making sure that what is submitted if you have to go to a hearing, it's properly prepared. If you need help with the forms, your help is there. But this is a marathon. This is not a fast process with or without an attorney. I will tell you that. Yeah, Michael says, is it necessary to prove a listing? No, you don't have to prove a listing. You can use any of the theories: listing, grid rules, functional capacity. In autism, if you've got no improvement, yeah, I think that's probably less likely you're going to be reviewed. But yeah, you don't need to meet a listing. Just like you don't need to meet a listing to win. TBI, PTSD, depression, ADD. Does one have a case? It depends. It depends on the symptoms, and it depends on the functional limitations. You do not win in a diagnosis. What exactly is weakness for back SSDI? Well, again, if you're talking about back, as in your back, your spine, that means that you've got loss of strength in your back that limits your functioning in terms of physical activities like lifting, carrying, twisting, turning, bending, stooping, kneeling, crouching, crawling, walking, climbing ladders, things like that. T-Lux says, hello, T-Lux. Laura Boudreau has been diagnosed with Mary Turner syndrome. I just looked that up a while ago. Let me just take a look at that again. Mary Turner syndrome, iliac vein compression, a condition where the left iliac vein becomes compressed, and it prevents blood from flowing properly from the left leg to the heart. So it's a pretty significant problem. Other joint problems, including the 58 years old, carpal tunnel. Again, you don't want a diagnosis, but I think that the symptoms you're likely to have would probably limit you to no more than light work. Says to me the grids probably apply. So I think that looks like a pretty good argument to me. How long I have to wait for the letter of approval in the hearing? And my appointment, or it's not an appointment, it's a hearing, December 16th. I would say December slow, so I would probably tell you, you should have a decision by the end of January. If you don't, there's not much you can really do about it. It can take 4 to 8 to 10 weeks, but I'm seeing them mostly in 4 to 6 weeks, if not sooner. Okay. SSA, Roger says, they made a decision in favor of monthly payments. Why no monthly payments? That doesn't make sense. Well, I mean, if you got a decision in your favor, why would there not be monthly payments? Did you owe money from a prior case? I don't did they tell you why? Okay. Not sure what that's saying there. Oh, initial spine doctor notes. I don't know what that says. Neurosensation intact, C5T1 dermatitis. Yeah, I would probably need to look at the MRI report. That doesn't really tell me anything. I don't, the 5, I don't know what that's getting at. But you copied it and somehow it got lost in translation, but that is not what I typically see in a medical report. Okay. So I'm sorry, yes, I'm not trying to be uncooperative, but that doesn't make sense to me, what you said. Byal says, thank you for answering my question. Part-time work, a lot of medical evidence, including imaging. How to understand the application? I've tried and fill this job. I think, you could put in the remarks section that you had multiple what are called unsuccessful work attempts. That's the term are to use, unsuccessful work attempts, and describe how long they lasted and what happened. You can add additional sheets. So I think that's where I would put it in the remarks section of your application. Can I address a claim 55-year-old BMI 52 about obesity and the problems that come with it at age 55? Obesity used to be a listing. It's no longer a listing. I think that with a really high BMI, it's going to probably affect you in terms of your musculoskeletal system, your feet. You may have issues with walking. I think that having evidence that indicates that your capacity to walk, maybe to breathe, to exert yourself is significantly limited, that's going to start eliminating jobs. And again, a person with a 52 BMI trying to do light work, walking 6 hours a day, that's going to be kind of hard. So I think that would be the medical side of it I would look at is to ask a doctor, your GP or another doctor, to translate what is the effect of that 52 very high BMI on your functioning. And that's what you really need. Having a BMI 52 does not make you disabled. Functioning loss does. Just difficulty walking or ambulating, flat feet, pain in the ankles, stress on the knees, maybe heart issues, whatever those are, how does that affect you functioning? And at the end of the day, could you walk, could you be on your feet for 6 out of 8 hours in a day? Nancy De La Cruz, 55 and severe anxiety, depression, go to therapy. What's the odds of getting improvement, exercise, and side effects? Anytime you have an anxiety disorder, depression, anxiety, it's hard because these are invisible illnesses. And I've said, in my mind, indicia of severity would be things like inpatient hospitalizations, not recent ones, suicide attempts, failed medication trials, ongoing treatment with doctors, and statements from your treating psychologist or psychiatrist that, these symptoms are debilitating because they interfere significantly with attention, focus, concentration, ability to maintain pace, to remember, to behave in a workman-like setting, interact with coworkers and supervisors. You want to get very granular as far as what this all means in terms of your functioning. So, at 55, there's a bias in your favor. The grids do not apply because it's not physical. But I think that, if your doctor or therapist is willing to help you, that can go a long way. But you want to identify specific problems that would prevent you from being reliable. Yes, GC Styles hits the nail on the head. It's not just your medical condition, it's how it prevents you from working. And look, doctors don't always talk about that. You got to ask them to do so. And I will tell you, sometimes you have to, if you give them a form to fill out or ask for a narrative report, sometimes you have to pay them. They may want to, they want to get paid to make an assessment of that. They may say, I can't make that assessment. If it's physical, they may say you need to go to a physical therapist and get a formal functional capacity evaluation. If it's mental, they may want to do a different, a more thorough vocational assessment as far as your capacity. So, but that's what you need. Okay, I filed for disability 1-6. It's Rep's final review. August 3rd of 2017. That makes 0 sense. You filed for disability on January 6th of 25. When you check the application, it says a rep started her final review on August 3rd. That's a typo. It doesn't make any sense at all. August 3rd, 2017. That makes 0 sense. I hope you see why. I mean, how could they say review started, 8 years before you applied? Makes no sense. All right, 58 years old always is in your favor, I think. Okay, yeah, and I think that this is the gentleman with CP, cerebral palsy, that, yeah, I think needing assistance in the restroom, an activity of daily living that you cannot do on your own, that certainly suggests that it would be really hard for you to maintain, performance at a job. And again, it sounds like the volunteer work you would be doing would be somewhat limited there. First time I don't have an attorney. Again, I think that mental illnesses are really, really hard cases unless there's really, really solid evidence. Um, they do deny many people, again, especially if you're not listing level, and since mental health cases can't be objectively determinable, objectively measured with an MRI or something, they are often denied, and you'll end up at a hearing. And again, you need really, really compelling evidence to win. And I think that I would also tell you there is a narrative in Congress that, too many people with mental illnesses, because they're kind of self-reported, are on disability. So there's going to be a move to kind of reduce that, make that even harder, I suspect. Matt says they'll have an answer by March. So gathering evidence, medical review, been waiting a year. Not bad or good. It's just, it's taken way too long. This is where, again, I would say reach out to your representative, your senator. Say, I've been waiting for a year. And why can't they give me a decision on it? Why is it going to be till March? I think you got to be a squeaky wheel. Ask for some help. Okay, the person for look at your knowledge. It's hard to get approved under age of 50. Just to clarify, the RFC stands for residual functional capacity. At age 50, it's sedentary. If you have a physical limitation, doesn't apply. The grids do not apply to mental health cases. It's got to be a physical limitation, and the grids only apply if you have no transferable skills. But big picture, GC is correct in that at 50, many times with the grids, the definition of disability becomes more lenient. Okay. S'mores the cat was awarded SSDI back in 2024. Got back pay for dependent child, so received back pay. That's too long, and you haven't received your monthly checks. I would get on the phone on that one, or contact your representative, your attorney if you've got one, or your elected representative. Either A, they change your onset date so there'll be no past due benefits, but you should not be. You should, at this point, you should have your past due benefits if they're going to be paid at all. I'm new to this channel. Well, welcome. I'm glad you are. Medical diagnosis, PTSD, depression, panic attacks, applied twice in the Valley. And I hope you are awarding the, well, I think you're, it says SS. I'm assuming you're in the San Francisco area. So I don't think there's any fires up there. Yeah, it's going to be tough. It's going to be tough. I mean, you got to have, as I said, strong support from your mental health professionals, evidence of, multiple failed medication trials, suicide attempts, inpatient hospitalizations. You're going to need a lot. It's tough. It's tough. Okay. Okay, if you're legally blind, well, again, look at the listing. Look at the listing for blindness. We'll tell you what that listing is. It's listing 2. Look at listing, and I'll put the link in the comment section here so you can see it. Of course, if you're legally blind, you might have to have somebody see it for you, but oh, yeah, there's going. Okay, so basically, there are 3 listings, 202, 2.03, and 2.04, that talk about the listings for visual loss. And I think that, you need to meet one of those. Otherwise, if you don't, you need to have something else that would be, limiting you from work. I suppose it's possible to win a vision case if you don't meet a listing. I've never done it, or maybe I've done it once, so I think it's an uphill battle. I think you really, probably need to be listing level or severe vision loss with something else. Death 1105. I'm a disability, cashed out my pension due to hardship in the left my job shortly when it my effect by the new changes. Again, I'm going to defer on that one. I don't know. I don't want to speak to the new change. I'll try to get somebody on who knows more about it than me. I don't deal with that on a day-to-day basis. The windfall, the change and that rule. So I don't want to. I just don't want to talk about something that I don't know enough about to speak intelligently about. Learned a long time ago. If you don't know something, don't guess. TBI side effects, all the mentioned, little not to mention neuropsychs and toasted basically too. Yeah, I mean, I think that, TBIs are they can, and sometimes you look perfectly fine, but your head is a mess. And you just, again, my case today, my client, very nice gentleman, worked really hard for many years. I mean, he was literally in tears the whole hearing. And he was a big guy, very, with his wife. I mean, he's 6'4", 300 pounds, big guy, did physical work, in tears. And TBIs will do that to you. Is May-Turner syndrome? I have to look to see whether it's a listing. I don't know if it's in a listing, but I think that 58 knee replacement, May-Turner, osteoarthritis, I think you got a pretty good argument. That would be a case I would look real closely at because I think it's potentially a winner. So fill out the form if you'd like me to take a look at it. I think it's potentially a very good case, Laura. Colton got denied multiple times, had for disability like 6 months. No, don't assume that. I think that, these cases take a long time. I would reach out to your lawyer and say, what's going on? But, the time frame on disability cases can be 2 to 3 years. So it can take a long time. Do they do surveillance? Remember the recommended 12 months? Rarely they can, but it's very, very rare. And they normally do the recommended 12 months. If it's a 12-month review, probably they will. Yep, probably they will. Jen is my paralegal. How are you doing? I know Jen said you'd be a little bit later today, so you made it. I'm glad you did. Why are the grid rules made for people with 50 paying under 40 with a registrar case get denied? The grid rules just reflect Social Security's recognition that people over age 50 will have a more difficult time finding work and that they are going to have a more difficult time bouncing back from significant medical problems. That's just what Congress put it in. You can win at 40 or 40 to 50 or 30 or 20, whatever. It's just the level of evidence you need has got to be a lot higher, and you don't have the grid rule argument to rely upon. So Congress put this in thinking that people over 50, this was a fairness thing for people over 50. There's been some talk about changing the grid so that they start at 55 as opposed to 50. Hadn't happened, but could that happen? Possibly. But the why is because that's what our elected representatives decided. We've got about 10 more minutes. Okay, most cases with ALJ go through 5 steps sequentially during the hearing. They don't usually do it formally, but in the decision, it'll be there. It'll be written up that way. The judge is really focusing on typically they're going to focus on, is it a severe impairment? Well, they do it in the sense, let me back up. Yes, answer is yes. They always ask, are you working? That's a step. Are they going to ask, do you have a severe impairment? That they're going to ask that. Is there something there? They don't ask if that's usually something described in the decision. Do you meet a listing? That's kind of done behind the scenes. Step 4 is, can you return to past work? They do talk about that. Step 5, any other work. Most of the emphasis is on step 4 and 5, I would tell you. And in the decision, you may see a judge say, this is not a severe impairment. They just have to address that, but that's not really discussed specifically in the hearing. Now, usually the judge will ask us to waive a formal reading of the issue. If you didn't waive a formal reading of the issues, the judge might actually go through the 5-step process. But usually it comes down to, 99% of the time, can you go to past work or anything else, which is step 4 and 5. J-Max says, I missed your question. If I did, I apologize. Let me see if I can find it. Okay, here we are. 48-year-old male, unemployable, vet, physical exam with severe degenerative disc disease, significant facet hypertrophy, and 30 leg raise. Will age be a factor? Yeah, it will be. I mean, your case would be stronger if you were 50. The VA determination is not, it's not binding on Social Security. Severe degenerative disc disease, what do the doctors say about your functioning? Does it limit you? Do you need to take unscheduled rest breaks? Does it limit you physically in terms of walking and standing? You know, are you on significant pain medication? They see more back pain cases than anything. So what you're talking about is, you know, a significant back problem, but you're 48. And, those are easier to deny than if you were 55. So, it's not, I'm not saying you won't win. I'm just saying that that's going to be more difficult than if you were 58 as opposed to 48. And how severe is severe? Is there disc involvement? Is there a herniated or bulging disc? Is there nerve impingement? What is severe degenerative disc disease? What does that mean functionally? And that's really where the rubber meets the road. What are the functional limitations that you would have, J-Mac? That's really the big question. I'm sorry I missed it earlier. Okay. Watching this evacuating from the fire. Ay, sorry to hear that. Okay, well, yes, that fire looks pretty scary. I have a cousin in Culver City, and I texted with her today, and she said it's still a little bit northwest of her, but they see a lot of smoke. So, I think anybody in that part of the country, if you're near the fires, you got to be ready to move quick because they're moving really fast, is what I understand. So, be careful. Be real careful. Bad communication. Yeah, look, I mean, honestly, we have a lot of clients. I mean, we're a small firm. It's myself. I've got several paralegals. I've got, a couple of attorneys I do some work with. My daughter may do some work. Not everybody is going to get a phone call every day, we can't do it that way. These cases take a long time. They limit our fees. And so we have to focus on, at the end of the day, what is going to win a case. And, I cannot get too caught up in the weeds in that, if somebody's emailing me every day saying, what about this? What about that? No, I'm not the right fit for them. This is not that kind of practice. The way I would tell people is if you were hiring a lawyer and that lawyer was charging $350 an hour and you got a bill every week, would you be emailing every day? Well, I think the answer is no. And so with these cases, they take a long time. So there's not a lot that changes very quickly. So I appreciate, Amy, it sounds like you understand that. But, to be fair, no, there are going to be times when people aren't going to hear from me for several weeks because there's nothing to report. And I don't have the bandwidth. I can't afford to have people calling up saying there's nothing to tell you. We sort of have an idea of how long these cases should take. And again, when we get more than 5 months or so in, we'll tell people, contact your congressperson. But, we're, again, at the mercy of Social Security. So, some people are not going to be happy because they want a call every week. And I tell those people, I'm not the right lawyer for you because I just can't do it. We just don't have the bandwidth to do that. And there's nothing to tell people most weeks. When we get a hearing coming up, yeah, you're going to hear from us once or twice a week because we got a lot of stuff to talk about. But during those months where we're waiting for a decision on initial or months waiting for a decision on recon, you're probably not going to hear very much. We have texting service. We text people. We have email blasts that go out. I have a bunch of videos out there. So I do try to communicate what I would tell somebody in a phone call. But when somebody calls me and says, what's the status of my case? It's two weeks after I filed the recon. With all due respect, nothing, because nothing's going to happen in 2 weeks. That's just not the time frame we're dealing with. But again, thank you, Amy. If I misunderstood, I apologize. Praying for you, Kevin J. Yes, I agree. Thank you, K. Wolf. I totally agree with that. Eric got a partially favorable. Does it mean you'll get a CDR? No. I mean, partially favorable usually means they change the onset date, but that is usually in the front end as opposed to the back end. At 38, yeah, you're likely to get more likely to get a CDR because you're younger, but the fact that it's partially favorable doesn't factor into that. I think your age is a more important factor. Okay, so we got a few more minutes here. Jason got an unfavorable. Could do past work. Past job was my past job. I got it wrong. That may be grounds for appeal. If the ALJ, improperly described your past work and denied on the basis you could do it, that would be appealable. And the vocational witness said no. So yeah, I would get an audio. Here's what I would tell you, Jason. I would get an audio of your hearing, and I would listen to it carefully. You'd be surprised how often people they remember something, but it was not what actually happened. So I would listen to it. I would take close notes on it. If in fact the judge description of your past work is not what it was, then I think that could be very much grounds for appeal. Roger Dunaway, I skipped your question. Roger, I hope I can find it because I got a lot of things in here. Okay, here we go. I've not received my award letter, but SSA has requested my settlement paperwork. Received a lump sum. I'm assuming for workers' comp. Should that affect monthly state payments? No. Assuming your workers' comp settlement had language, they call it Hartman language, that basically said that your settlement reflects payments over your expected lifetime. And if it has that in there, your payments will not be affected, or a very, very limited effect on it, because they're going to look at it as if you're being paid over your lifetime. Okay. All right, so we're getting close to the end here. Let me see if I've got a couple more. Melissa Smith, neck and back, fusion denied November 23rd, just an appeal. Struggle standing, she was, yes, submit the absolutely grid rules. I think that's a good case. I think you've got a good case, Melissa. That would be one I would definitely take a look at. It's a good case. And if you get turned down and you're not represented, reach out. That's a good case. Yeah, okay, if you appeal, file on your own, you would not have online access to it. We have it through something called ERE. You would not have access to that. I don't know why. I wish they could give it to you, but they don't. Okay. Kevin's a brain injury survivor. Let me take one more question. Okay. It's the best to get my medical records beforehand. Hit by a car, TBI, severe anxiety, been a psychiatrist. You can submit records with your application. Generally, they want to get the records themselves, but I don't think it's a problem to submit them. You don't need them. What you really need is the names and addresses of your doctors, more so than having the records themselves. So don't let not having the records slow you down. I think it's more important that you get the names and get the application in. Thank you, Death. I appreciate that. All right, let's see if we've got any more here we can go to, and then I'll finish on this one. How do you request your Social Security file? It kind of depends on, I think that, if you're talking about a disability case, you can make an appointment with Social Security and go down and physically look at it. You could do a Freedom of Information Act to request it. But if you're in the middle of a disability case, the best thing to do if you don't have an attorney, would be to make an appointment and physically go down to the Social Security office and look at it in their office. And it's hard now because their offices are making it really difficult to make appointments. But and again, I'll just say it is that part of the advantage of having an attorney involved is we can get access to stuff electronically that you are going to have a hard time getting because going down to the office is not as easy as it used to be. This is just another example of Social Security making things, unfortunately, more difficult than they need to be. Okay, here's one more I'll get to, and then we'll close it. Currently in disability since July of 21, reached my full retirement age in May of 25. Need to be concerned about income limits income to reach full retirement in 4 months. You're pretty close. I don't think that there's going to be any issue with your disability case before your retirement, and they'll automatically move it over. So I wouldn't be too worried about it. I think that nothing much is going to happen between now and May, is my take. Okay. We are now at a little bit over 2 hours. I really appreciate everybody joining me. I think we had 150 people here, which is great. And keep those questions coming. We'll do it again next week. And again, I will try to pin down some of the folks that I know are going to be coming on. And then I think we'll just, again, keep answering those questions, keep them coming. Stay warm, everybody. If you're in California, be careful about those fires, and God bless. Just hang in there, because it's a crazy time right now. So I'll end it right now. Thanks for everybody for coming, and we'll see you next time. If you have any questions, here's how to reach out to me at the bit.ly #ContactJonathan3. And if you found this useful, please do leave me a review. Thanks a lot. Take care.